Hello, I'm James Allen, an Equal Employment Opportunity Specialist here at the Department of Education's Equal Employment Opportunity Services Office, also known as EEOS. On behalf of Acting Director Michael Chu and all the EEOS staff, welcome to the Department of Education. Today I'm going to talk to you about EEOS's role and the services we provide. Next, I'm going to discuss the prohibited bases of discrimination here at the department, along with certain forms or types of unlawful employment discrimination. Then, I'm going to explain how you can initiate the EEO complaint process if you feel you're being subjected to unlawful employment discrimination. I'll briefly go over the EEO complaint process and identify the EEO laws and regulations that protect you as employees of the department. Finally, I'll tell you how you can contact EEOS. The Equal Employment Opportunity Services Office has several important responsibilities. First and foremost, EEOS processes and investigates complaints of unlawful employment discrimination filed by Department of Education employees and applicants for employment at the department. By regulation, EEOS must remain impartial throughout the complaint process, and at all times, EEOS serves as a neutral party in that process. Our office does not represent or advocate on behalf of individual employees, managers, or even the agency as a whole in the complaint process. EEOS also provides information and counseling about the EEO complaint process to both employees and managers. In appropriate cases, we attempt to resolve allegations of discrimination through settlement agreements that are agreeable to both the complaining employee and management. We provide training on EEO laws and regulations both online and in person. As I mentioned, EEOS processes complaints of unlawful employment discrimination. But what exactly does that entail? Pursuant to federal laws, regulations, and Department of Education policies, which I'll discuss briefly a little later, there are certain prohibited bases of discrimination, or in other words, certain reasons for which it is unlawful to take an adverse personnel action. The following are prohibited bases of discrimination here at the department: race, such as Caucasian, African American, or Asian American; color, such as white, brown, or black; religion, such as Christianity, Judaism, Islam, or atheism; sex, male and female, but also including pregnancy, gender identity or transgender status, and sexual orientation; national origin, such as Hispanic; age, for those 40 and above; disability, including both physical and mental disabilities; genetic information, including information about certain family medical history, or medical documentation showing the presence of a genetic marker that may lead to certain medical conditions. Retaliation. It's very important to remember that with respect to the EEO complaint process, the only retaliation that is prohibited is retaliation for having participated in EEO activity. EEO activity includes participating in the EEO complaint process or otherwise opposing unlawful discrimination. Other grievance procedures may prohibit retaliation for other reasons, but in the EEO complaint process, only retaliation for having engaged in EEO activity is prohibited. And finally, political affiliation and status as a parent. Again, it is unlawful to subject an employee to discrimination on any of the bases I just discussed. But what does discrimination look like? I'm now going to go over some of the most common forms of unlawful employment discrimination. One form of unlawful employment discrimination is disparate treatment in terms or conditions of employment. Or in other words, treating an employee differently with respect to any tangible benefit or privilege of employment that an employee receives. Examples of terms or conditions of employment include performance appraisals or bonuses, pay, promotions, telework, and leave. I'll give you an example of disparate treatment. A hiring manager chooses Jessica for a promotion over Jason because the manager wants a woman to have the job. This is disparate treatment on the basis of sex because the manager made the hiring decision on that basis. However, if the manager had selected Jessica not because he wanted a woman for the job, but because she had superior qualifications, the hiring decision would not constitute unlawful employment discrimination or disparate treatment, as the hiring manager was basing the hiring decision on qualifications, not the prohibited basis of sex. Harassment is a second form of unlawful employment discrimination. Examples include unwanted sexual comments or sexual advances, racial epithets, or derogatory age-based comments. In addition to being able to pursue an EEO complaint through the EOS office, employees who believe they have been subjected to unlawful harassment can report the harassment to their managers. If an employee alleges that his first-line supervisor is the one engaging in the harassment, the employee can report the harassment to a higher-level manager. Pursuant to the department's anti-harassment policy, managers who become aware of allegations of harassment have a duty to conduct an investigation into that harassment, separate and apart from the EEO complaint process, even if the employee has filed an EEO complaint, and to take corrective action if the allegations are substantiated through that investigation. A third form of unlawful employment discrimination is the failure to provide an adequate, reasonable accommodation to a qualified individual with a disability. By federal law, qualified individuals with disabilities are entitled to accommodations that enable them to perform the essential functions of their job. The accommodation provided must be effective in assisting the employee to perform the essential functions, but the employee is not necessarily entitled to the accommodation of his or her choice. The Department of Education does not tolerate discrimination in any of its forms on any of the bases I discussed earlier, and department employees are entitled to a workplace free of such discrimination. If you believe you have been subjected to unlawful employment discrimination and you would like to initiate the EEO complaint process, be sure that you contact EEOS within 45 calendar days of the action that you allege to be discriminatory. For example, if you believe you were not selected for a promotion on the basis of your sex and you wish to initiate the EEO complaint process, be sure that you contact EEOS within 45 calendar days of the date that you learned you were not selected for the promotion. Failure to contact EEOS within 45 calendar days will likely result in the dismissal of your complaint, so it's very important that you contact our office within that time frame if you wish to pursue a complaint. The EEO complaint process has both an informal or pre-complaint stage and a formal complaint stage. The pre-complaint or informal process begins when an employee contacts EEOS and indicates he or she wishes to initiate the complaint process. A counselor will meet with the aggrieved employee to allow the employee to explain the allegations in more detail. The employee has the right to remain anonymous at this stage, but if the employee elects anonymity, the counselor will be unable to attempt to resolve the complaint. Assuming the employee does not elect to remain anonymous, the counselor will contact the alleged responsible management official to try to resolve the matter. Or in many cases, the counselor will afford the employee the opportunity to participate in the department's alternative dispute resolution program. For whatever reason, if there is no resolution at the informal stage, the employee will be issued a notice of right to file a formal complaint. The formal EEO complaint process begins when, and if, the employee submits a formal complaint of discrimination to EEOS. Our office will examine the complaint and issue a procedural acceptance or dismissal letter. Typically, a complaint will be accepted for investigation if it alleges one of the forms of unlawful employment discrimination I discussed earlier. However, failure to abide by the 45-day time limit for contacting EEOS is a common reason for dismissing a complaint. If the complaint is accepted, EEOS will conduct an investigation and issue a report of investigation. In most cases, after receiving the report of investigation, the employee will have the choice to have the complaint decided by an Equal Employment Opportunity Commission administrative judge or through a final agency decision issued by our office. If the employee is dissatisfied with either decision, the employee has the right to appeal the matter to the Equal Employment Opportunity Commission or to file a civil action in U.S. District Court. These are the EEO laws and regulations that protect you as employees of the department. I'm not going to go over each one individually, but if you have any questions about any of them, feel free to contact EEOS. The Department of Education has also issued policies prohibiting unlawful employment discrimination and harassment. These policies are available on EEOS's page on ConnectEd, the department's internal informational website. If you are interested in initiating the EEO complaint process, or if you'd like more information on any of the topics I've discussed today, contact EEOS at 202-401-3560 or by email at om_EEOS@ed.gov. One of our staff members will be happy to assist you with your concern. Thank you for your time today, and again, welcome to the Department of Education.